Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about an upcoming criminal trial involving a claim of self-defense and why I think that claim of self-defense is going to fall pretty flat. I'll have more on that in just a moment. So on September 22nd, 2020, Jason Clearman and his wife were driving along in Milwaukee, Wisconsin. And a gentleman was in the middle of the road on his bicycle, and they had to swerve around him. Apparently, words were exchanged, and the man on the bicycle reached through the driver's side window and punched Mr. Clearman. Mr. Clearman followed him. Mr. Clearman was unarmed. He was 54 years old, an immigration attorney, no history of violence. He was simply trying to find out who this person was in order to likely call the police and press charges. He was, after all, assaulted. So when they turned the corner, he stops his car and he gets out and he goes to confront this individual. Now let's stop right here. Let's dispatch with all of the naysayers who are going to say, well, he should never have gotten out of his vehicle. I agree. One of the first principles of self-defense is if you get hit, nobody ever sees the first punch thrown. They only see the second punch thrown. So what Clearman should have done, obviously, and of course in 2020 hindsight, is just drive on and file a police report. Because sooner or later, the police would have done something about this guy. But that didn't happen. He stopped, he went to confront him, and the guy on the bicycle, the guy by the name of Theodore Edgecomb, pulled out a pistol and shot Clearman and killed him. He then got back on his bicycle and pedaled away. After that, he got in a car and drove all the way to Kentucky. So the police did an investigation. They identified who this person was. They went down to Kentucky and they arrested him. And he admitted that he had shot Clearman, but he claimed self-defense. So there's a video involved, and I want to show you just a little portion of that video. Okay, as you can see Edgecomb here in the circle, he comes around, he pulls around the corner. Clearman follows him around the corner, and then he's going to jump out of the car here in just a second, and when he does, he's going to approach Edgecomb. Edgecomb's going to turn and shoot him. You can see it right there. Bang, he shoots him. He's dead. So, having seen this, the only thing you can really tell is that Clearman is reaching for him, no doubt to confront him, but he has no weapon in his hand. He has no obvious weapon in his hand. And this guy just turned around and shot him. So, let's look at the law of self-defense as it applies. Now, this is Wisconsin, the same state where Rittenhouse was tried, and in order for there to be self-defense, what's the first thing? You cannot be the primary aggressor. In other words, you can't have started the fight unless you withdrew from the fight and made it clear that you were withdrawing from the fight. Now, Edgecomb may have an argument that he withdrew from the fight, but he also knew that he had started this entire encounter. Now, to be fair, Edgecomb's family and friends, there are a number of them, claim that Clearman was drunk. There's been no evidence that I have seen that supports this. They claim that he was the aggressor. They claim that he was going to hurt Edgecomb and that Edgecomb was, in some way seriously afraid for his life. From a 54-year-old guy when he's a 31-year-old fellow, 32, 31, a fellow who's obviously in good physical shape and not facing a weapon. In fact, it appears he didn't even look to see if he had a weapon. He just shot him. So the video is going to be important evidence, but it's not going to be all of the evidence. In order to make a claim of self-defense, Edgecomb will have to testify. And by virtue of having to testify, he is going to have to answer other questions. Number one, why did you flee to Kentucky? Well, let me explain why he says he fled. Well, let me explain why he fled to Kentucky. He says that he was a prohibited possessor. In other words, he couldn't lawfully have possession of a firearm. So he's out there committing a misdemeanor anyway, right? And as a result, he was afraid that he'd get arrested for having a firearm. Not for shooting a guy and killing him, but for having a firearm. Okay, that makes no sense whatsoever, and a jury is not likely to accept that explanation. But the next critical inquiry is, well, why are you a prohibited possessor? Well, not because he's a felon, but because he's been convicted of misdemeanor domestic abuse. And when you've been convicted of misdemeanor domestic abuse, you are a prohibited possessor. You cannot own or possess a firearm. Now, if you think about that, domestic violence, that is something that's going to be very hard to overcome. Now, it may be that the judge will limit the cross-examination on that issue to, I was a prohibited possessor. I couldn't lawfully own a firearm. And they won't get into the obvious history of violence here. In fact, if I were the judge in this case, that's what I would do in order to ensure that he got a fair trial. As I have said countless times on here, when you are thinking about wanting to see somebody who you think is guilty punished, you should absolutely wish for them to have the very best criminal defense available, and you should absolutely wish for the judge to give them the breaks to the extent that it's lawfully allowed to do that. He should give them the breaks on evidence and everything else. And the reason he should do that is because if the person gets convicted, the conviction is going to withstand appellate review. And all of these cases get taken up to the appellate court. So it'll be interesting to see how this case comes out. Right now, I don't believe Mr. Edgecomb has a serious claim of self-defense. You see this a lot. And you see it a lot when you're in this situation where there is some kind of a fracas where somebody starts something and then they finish it with a gun. They start it with a punch, they finish it with a gun. That is not the way self-defense was meant to work. It's meant to work that if somebody attacks you and you reasonably fear for your life, you can defend yourself. Now, the Edgecomb is charged with first-degree murder, second-degree murder, and with, I believe it's a reckless homicide. And self-defense is not a defense to reckless homicide. It just isn't. If the jury believed that he was in fear of his life, but not reasonably in fear of his life, they can convict him of the crime of reckless homicide. And that may wind up being the best outcome. Now, one other thing I want to mention, the prosecutors doubled down on this case. They increased the charges from reckless homicide, which was originally the first charge, up to first-degree and second-degree murder just the other day, a week before trial. And of course, the reason that prosecutors do that is to force the person to take a plea deal, because now you're not looking at 10 to 20 years in the state prison for reckless homicide. Now you are looking at possibility of life in prison, life with parole, sometimes life without parole, depending on what the charges are, where the conviction winds up. So it's really a question of, do you want to gamble on spending the rest of your life in prison, or do you want to gamble on being able to get out while you're still young enough to have a life after prison? That's a pretty difficult choice for somebody to have to make, particularly if they believe they're honestly not guilty. But for someone who has experience in the criminal justice system, as Mr. Edgecomb does, as he has gamed the system previously with misdemeanor convictions, he no doubt feels that he can get through this, and he could probably have pled this down a little bit further than reckless homicide. The prosecutors have pretty much informed him, no, you can't. the best deal you are ever going to get is likely going to be on negligent or reckless homicide. So we'll see what happens. It'll be an interesting thing to see. Court TV is going to air the trial live, which probably means that there'll be a live stream of it and that you can look at it online at the time of trial. It'll be an interesting case because there's a racial dynamic. Edgecomb is black and Clearman is white, and that will play into the case. And I think it's sad because the race should not matter. This is either a justified shooting between two citizens or an unjustified shooting between two citizens. Race should have nothing to do with it. So that's where we're at. If you haven't already, please go over here and subscribe to our channel. And if you haven't already, touch the like button, give me a like, and if you've subscribed, touch the notification bell so that you can be notified whenever we do a video here on the channel. Thank you very much for watching. If you have any comments, leave them in the comments down below, and just remember to keep it family friendly. I don't mind you disagreeing, but you have to disagree politely and respectfully, and because a lot of people read this, and I don't want to see anybody's values offended by bad comments. So if you would, please take a moment, leave a comment if you like. Thank you so much for watching. Have a terrific day. I'll catch you on here next time.